So in terms of successful mediations, the one thing which we've all come to realize is that despite banking being about money, there are a lot of feelings involved. So we've had instances where we had this particular individual who, according to the bank, was a perennial defaulter. She hadn't paid. She's been suing the bank. She has like 6 cases pending against the bank. And if you look at the amount of money outstanding, it's less than 300,000 Kenyan shillings. So we had this discussion multiple times until eventually we were summoned to a mediation. And during the mediation, she will not refer to her pleadings. She only refers to the fact that what happened to bring the bank is that she's always been paying her debt. One time she defaulted. She called the people in the marketing committee, told them that, look, I will be paying, but I'll be paying a bit late. So the people in the credit committee decide, this lady has financed her car with us. We can go pick up her car. So she was in church with her kids on a Sunday. People came in, threw out her kids' items from the vehicle, took the car from church, all her church seeing her. So according to her, it doesn't matter how much money the bank thinks she owes them. She had said she'll never pay the bank a single shilling, because according to her, the loss she has suffered is more than sufficient. So having just 2 mediation sessions where she was able to express her feelings, then eventually, of course, get an apology, because she wanted an apology. Then it was a very simple issue, 300,000, I can pay the money tomorrow. But it took almost 8 years to get to the point where instead of looking at it's just about money, you've defaulted, you owe us money. It's, of course I default, but then why would you but still remind me about my small loan which I hadn't paid? So we discussed also discuss the emotion.
Let's come back to the gentleman in front. Please give him a mic. We'll share ours.
Thank you so much, and sorry for that. I want Hedaya and Stephen to explain to me on 2 scenarios. And I want to give you a very good example on some cases that way you handle in your departments. There is a time we have your clients, maybe deceased, and I can call them, and you fathers and parents will forgive me for using that name. They say that we may have notorious parents in our institution. They have a business, they have savings in banks, but even their spouses, their relatives, the kids are not aware of. And unfortunately, maybe he or she dies. How do you handle the savings of this man or this woman so that the children can benefit? It reach a time, bank can transfer those funds into the third party, which is unclaimed asset. You remember the other man, unclaimed asset authority says they have 8 billions in their account, which has not been unclaimed. Why? Because nobody is going there and say this is the money for my father, for my mother, or whoever. Within the bank, what are the processes are you using to identify the genuine beneficiaries of this fund? And maybe in the other side of the unclaimed asset, because everything is digital right now, you can use the core beneficial, the principal beneficial ID. You log into the unclaimed asset and you will find it has millions. I want to give you a very good example for me. I log into my eCitizen and check on my father's unclaimed asset. And I found my father had around 200,000 in the account. Hata yeye mwenyewe hajui. But some people whom their parents are dead, when they want to access this fund, they are told, bring a written letter from the chief, from whoever, and which end up they are losing their
it can be done, yes, depending on the procedures of each bank. Once that is done, allow me to speak in legal jargon, the bank is actors official. It is not the bank's duty to determine that these are the legitimate beneficiaries of the account. What the bank does is to make sure that whoever it is who is presenting these documents is indeed the person named. So we do some KYC on the administrator and not the beneficiaries. How they choose to distribute that money is generally up to them. Should they now have a dispute, that is a dispute that can either be taken to the courts or the mediation team. And once an agreement is reached and presented to the bank, then the bank will comply with such an agreement. I hope that answers your query.
Thank you so much. Now, can we, for this panel, our time is up. Thank you so much for listening to us.
I think now we can clap properly for them. Yes. Thank you so much, Wakilis, and for the great job. We are going to request Honorable Lady Justice Lucy Gasheru to help us award this panel. Let's appreciate Lady Justice as she comes to do this noble work, noble charity work. Okay, so we'll start with Senior Stephen Maloa. Let's appreciate Senior Maloa. Maloa, seems like your gift was not shipped. But there it is, there it is. Let's appreciate Senior Maloa. Great. We're going to have Senior Edaya. Almost everyone is my senior, so allow me to call them that. Senior Edaya, let's appreciate her. She gave us a wonderful perspective. Senior Victor Njenga. Let's appreciate Senior Victor. And the wonderful moderator for keeping time, Senior Advocate Rogers Monda. Thank you so much, everyone, for that wonderful discussion on banking. And just for context, banking was the first ever mediation summit that we convened. Now, one of our partners who supported this mediation summit, I&M Bank, so they have a stand just outside the hall. So if you are in need of investment and financial services advice, they are more than happy to help. So please pass by and they'll be most grateful. So now I want to invite Francis Otunga. We've been sitting for a little bit and we took lunch, yes? So Francis is our colleague at the university and is going to help us a bit stretch. And you're going to have a small interlude of a play by our wonderful students who have been helping as ushers, again on mediation, and then we'll jump into the last panel of the day. We hope to still keep time. So karibu sana, Francis.
Hello, ladies and gentlemen. How are you doing? You see, my biology class told me that, my biology teacher told me that once you go for lunch, and after lunch, normally watu wanalala sana, si ndio? It's because the food has gone to digest. The blood has gone to pick the nutrients from the stomach to the brain, si ndio? So right now, chances are the blood is in the stomach and then the brain is a ghost town. Eh? Yes, so let us do a bit of stretching. You can just stand up where you are. Stand up where you are. Yeah, you can high five your neighbor while at it. Eh? Just tell them, I'm happy to see you. Make sure you're smiling. Eh? Yes. Okay, okay. On that note, normally, I advocate for something we call living in the moment. Eh? Make sure, ask your neighbor, are you living in the moment? Yes. So, I want to remind you one nursery rhyme that I really love to sing to. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. Okay, now at least part 1 of A, everyone amepata. Tuko pamoja. Now you'll be clapping once, and then you find a neighbor and high 10. Tuko pamoja. So you'll be doing this. Clap your hands, pop, pop. You find someone. Are you together? Are you ready? Okay, okay. And make sure you change that person every other time. Are you together? So please identify your 3 people. And are you ready? In 3, 2, 1, go. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. Mbona mbadilishi watu wewe? Wewe. Okay, now we begin now seriously, eh? Now tukue serious. Okay, now, are we ready now? You have understood what you're doing? Alright, in 3, 2, 1, go. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. If you're happy and you know, and you really want to show. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. Kuna yeah. Order, honorable members, order. Okay. At least you have said hi to a few of your colleagues, Sindio? Okay, the other one, I'm just confirming that you're here because normally I am the social wellness person at Strathmore University, and what we do is help people to increase their happiness index without necessarily increasing their salaries. Are you together? Anyway, now, so your right hand, you are both your hands up, like this. Say, I'm alive. I'm awake. I'm using one hand, so use both hands. Are you together? I'm awake. I'm alert. Enthusiastic. I'm alive. I'm awake. I'm alert. Enthusiastic. Situimbe kawimbo bas. The song goes like this. I'm alive, awake, alert, enthusiastic. Tuko sawa? Aya, now you remember what you're doing, eh? Let's go with the song in 3, 2, 1, go. I'm alive, awake, alert, enthusiastic. I'm alive, awake, alert, enthusiastic. I'm alive, awake, alert, awake, alive. I'm alive, awake, alert, enthusiastic. Watu wanaingiza mkono kwa mfuko mwenzako. Tafadhali don't do that, eh? Don't do that. Now this is the last time to harakisha kidogo. I'll have to stretch and then we sit down and then we see what is in store for us. Are you together? Are you ready? In 3, 2, 1, go. I'm alive, awake, alert, enthusiastic. I'm alive, awake, alert, enthusiastic. I'm alive, awake, alert, awake, alive. I'm alive, awake, alert, enthusiastic. Clap for yourselves, Lakini. Clap for yourselves. Clap for yourselves. Yeah. Now, at least now we can have our seats. We can have our seats and be ready for the next program. Asanteni sana. Thank you so much. Have a good one.
Okay, so we move on to the next phase. Over to you, Agai.
Good afternoon, ladies and gentlemen. Can you hear me? Can you hear me, ladies and gentlemen? Can you hear me? I can't hear you. Okay, this section will be a play presented to you by our esteemed ushers, who will be playing a skit, a mediation skit, showing us how the ideal mediation takes place. So this skit is about a land dispute between daughters, which has been in court for a long while with no meaningful progress. We see frustration and meaningless animosity between the daughters. The skit is named The Land of No Peace. The first scene is the courtroom, the never-ending case. The courtroom is filled with villagers murmuring. The judge enters and sits. The clerk calls the case.
Case number 3421, the case of the land of Mzee Ocheng, Akongo versus Achogo.
Ladies, are you aware that this case has been in court for 20 years? Every ruling delayed, every decision moved. Advocate Akil, what is your client's position?
My client is the rightful heir because she is the firstborn. Custom dictates that she takes full control of the land.
Your Honor, my client Achogo is also a rightful heir of the land. The late father was the owner of the land and wished for it to be shared between the two daughters.
And yet, here we are again. Have you two ever come out of court and talked like sisters?
Your Honor, there is nothing to discuss. The land is mine.
No, he wanted us to share. He told me so himself.
Omera nyako. Hii shamba tumesema tutaidivide. Kama baba yako akisema tunataka kuidivide, tungeiweka kwa karatasi.
There is nothing to prove here. I am the firstborn daughter of Mr. Ocheng. That land is rightfully mine.
Okay, no, it isn't.
Enough! This case must go to a hearing. I need a date. Now. Where is my calendar? Hakuna calendar kotini? Aya. We will pick a date, okay? How Easter is next week. My annual leave is the week after. Too many cases, okay? Advocates, what say you? 20th March 2027.
Great esteemed judge whose guidance we seek today. My client believes that 24th March 2030 works for us.
Your Honor, this cause, being ripe for deliberation, craves the court's indulgence in appointing April the 23rd of March 2025 as the day upon which it will be heard in earnest
Enough.
And resolved.
Enough. These too many dates. We can't do this. This case must go to mediation. Case closed.
After a chaotic court session, after the chaotic court session that we have witnessed, the judge has referred the case to court annex mediation under the help of a certified mediator. We see the mediator setting the room to facilitate the session. This is a co-mediation of two mediators, whose advantages are: one, in case one mediator forgets something, the other one is able to raise it. And two, we have different perspectives, therefore a variety of opinions. The second scene is mediation under the two co-mediators. Akongo and Achogo sit opposite each other. The co-mediators watch them as they help them to come to a meaningful settlement.
How are you?
Welcome.
Hello, welcome.
Welcome.
Welcome. Hello.
Karibu Akili.
Hello, karibuni sana. You can have your
Thank you.
seats. Thank you so much. Thank you so much for coming into the mediation session. Thank you, councils, for allowing your parties to participate in this. We sent you a commencement of mediation, and indeed, you've honored. We are really privileged. My name is Daisy Cherono Kerich Karaoke. Daisy is a mediator working in 5 courts in our republic. And I'm so excited to see you today here in this mediation session.
Welcome. My name is Samson Ouma, a mediator working in 7 court sessions in Kenya. Karibu.
Thank you so much. Now, I want you to relax. I know the journey might have been stressful. How was the journey?
Nimechoka. Nimetembea kutoka huko. Ndio nikuje hapa. I hope you do something.
Asante sana. Thank you so much.
Mi bado nangoja ugali.
Unangoja?
Bado nangoja sembe.
Oh, unangoja?
Nimepewa chips pale
Ugali.
kwa.
All right.
Hakuna heshima kwa mzee.
Okay. Asante sana. Thank you so much. How was the journey?
Mimi nataka tu hii kesi iende. Nimechoka sana.
Wow. Asante sana. Council? Yes.
Yes, the journey was rough, but we're happy to be here. We look forward to our consensus. Yes.
Wonderful. Thank you so much, Council. Thank you. I think that mic has a problem. So thank you so much. Now, mediation. What is it all about? How many of us have ever been to mediation before? Wow, Council. Oh, great. How was the experience in mediation, Council?
It was a fantastic experience. We managed to get to a conclusion that was beneficial to both parties. I really enjoyed it.
Wow, thank you so much. Thank you so much, Council. Thank you so much. Thank you so much, Council. So, just to take you through, mediation is an alternative dispute resolution process where parties are able to come up with a solution for their own issue. So I'll invite my fellow co-mediator to take you through briefly what mediation is all about. And we are neutral. We are neutral and we are not judges. We have come here to help you resolve your dispute. I am a facilitator. My colleague is also a facilitator. We are going to facilitate the process of mediation. We will not give you the answers. You will come up with a solution that well fits this case. So we are going to take like roughly 2 hours. Is that okay with you?
Yes, it is.
2 hours. Flexibility, 2 hours. Just in case we go into another 30 minutes. All right, thank you so much. So 2.5 hours. So we need to accommodate each other in this room. The councils are here and you're really welcome. We need to understand the role of each party in mediation. As facilitators, ours is to facilitate the mediation process and make sure that the process is moving very, very well. The parties in this session, your role is to act in good faith. Your role is also to sign some of the documents that will be availed to you. Like, for example, an attendance sheet. You'll be able to append your signature there to just tell the court that we came to this mediation process. You'll also have an agreement to mediate. I hope everybody came here voluntarily. You'll be able to append your signature on the agreement to mediate and also a confidentiality. Whatever we speak here will remain here. So I want to invite my colleague to also take you briefly through the norms that will guide us.
Thanks so much. We really appreciate you for having come here voluntarily. Now, if you agree to engage, we request that we follow these rules voluntarily again. Number one, we request you to respect one another. Yes? Now, number two, we request us to not to intervene when one is speaking. Each and everyone will get a good time to speak. Remember, we have given you something to write. If you feel like saying it, kindly write it. You will respond when your time comes. Number three, we'll ask you not to walk away. If you feel like walking away, kindly see us aside so that we get a feel what makes you want to walk away. Otherwise, you are really free. Number four, there are sometimes that we may have separate sessions. Normally, we call it caucus. Please, these are a process that help us move on. So when we ask you to be aside, does not mean that we are going to talk about bad about someone. Let's avoid to attack. Let's not attack. Let's be as smooth as possible.
Then now let's know who is in the room. I know I gave you an attendance sheet, but it is important to know who is in the room, because according to this file, we need to confirm that you're the true parties in this case. Thank you so much. And feel free. Which language are you comfortable? English. Council is comfortable with English?
Yes, I'm also comfortable with English.
All right.
Kiswahili.
Kiswahili. All right. That tells us we have to bring a balance so that tutumie Kiswahili na pia Kiingereza. Asanteni sana. So wacha tujue ni nani yako hapa na kwa majina. And your preferred name that you'd want us to use in this session.
I'm a Kwongo, the firstborn daughter of Mr. Ochieng.
Okay.
My name is Achogo. I am the second-born daughter and the most loved daughter of Mr. Ochieng. Achogo.
Thank you, Achogo. Okay, did I get you right?
Yes, the most loved daughter.
Most loved daughter. All right. Can we just say the daughter of the deceased?
I mean, sure.
All right. Thank you. Thank you. Please give it to the other.
Kwa majina mimi ni Sigana. Mimi ni shangazi ya Akongo.
An aunt, eh?
Yes.
All right. Please give to the council. We also need to know the council.
My name is Advocate Okil, and I'm here for my client, Akwongo.
Akwongo, okay. Thank you. Akile. All right. Okil. All right. Thank you.
I'm Advocate Ochiko, Senior Counsel. Make sure you write that down. Yes. Here for my, you've written it. Yes.
All right.
Senior
All right.
Counsel.
Yes. Well captured. Ochiko.
Yes. Ochiko.
All right. All right. Thank you so much.
Senior Counsel. You've gotten that part.
Senior Counsel.
Senior
Oh,
Counsel.
okay. 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 Thank you. Thank you. That is well noted. And in this case scenario, we also need to give you the roles of the councils in the room, so that we understand this mediation process and the roles of each and every party. I don't know whether I had mentioned that before. Had I mentioned the role of the councils in mediation? Definitely your role is to support your client. In mediation, we say the party has the autonomy to make a decision. It is not like the court process where you represent your client through the litigation process. Here we give ability for the client to be able to fully open up, fully come up with a decision that they can be able to implement. I hope that is clear. Thank you so much. Thank you so much.
Thanks so much. Before we give you a chance to now speak, I want to remind us that there are three possible outcomes in this mediation. Number one, we may have full settlement, meaning all the issues that we have agreed and signed all of them. Number two, it is possible that we can have a partial settlement, meaning some of them you have agreed on, some you've not agreed. And number three, it is possible that we may not agree on everything, meaning an unsettlement. For us, what will come out from you is what we support.
Wonderful. And then it's also important to note about the advantages of mediation. That one, it is going to mend relationships. Two, it is also going to save time. From the look of things, this case has been in court for 20 years. Imagine, within the 2.5 hours, we can conclude this matter. Is that a good thing? Wow, thank you. It will also help you in terms of, it is a win-win. It is a win-win. So everybody is going to get out of this place having achieved that ability to have a win-win. And also, it's important to note that it is cost-effective. You will not pay us as the mediator. The court is going to pay because this is a court-mandated process. So nobody is going to ask you for anything, and that's why you are sent for court-annexed mediation. Is that clear? Very good.
Thanks so much. Before we give you a chance, I want to appreciate counsels for being patient to be here, and even for allowing your parties today to speak for themselves. Thanks so much. At this time, I want to ask either Akongo or Achungo, who is first.
Achogo.
Just to help us. Remember, we said that we'll give one person to speak at a time. So I want us to give one person to speak. We start with her. Okay.
Are you comfortable?
Okay.
Okay.
This is your turn. Karibu.
So once again, my name is Achogo. As I clearly stated before, my father had told me that he wants my sister and I to share this land. My sister doesn't even require this land like I do. I have a husband, I have children, and she has neither. So what will she do with the land?
Chensi. You don't understand customs anymore. Kuna nini ya kusemwa?
Sorry, Chungo. You remember we requested one to speak at a time? Thank you.
Thank you so much, mediator.
Okay.
As I was saying, my father spoke to me before he unfortunately died 20 years ago. Can you imagine? 20 years ago, and she has been refusing to come to an agreement. I just want us to share this land fairly. 10 acres, 10 acres.
Mediator, let me tell you, I'm the one who knows. You see custom says.
Just before you come in, I don't know whether you are done.
Yes, I am done. Thank you.
Okay, thank you.
So because of time, we have to stop there, but definitely you got a full settlement. Say hi to each other and then we leave. So they got a full settlement and they are hugging each other. The beauty of mediation. Thank you.
Thank you so much. So please help us reset so we can get the rest of the ushers to help us set up again. Thank you so much. Let's appreciate them. Let's appreciate them. A lot goes into that for people aspiring to be lawyers and qualified mediators, yeah? To spare some time to just come up with some drama to make us understand the process of mediation. If we had time, we'd have proceeded, and I'm sure you'd have enjoyed a bit better. But you are the mediators, yes? You know how it goes on from there. So as we continue to set up for the final session of today, and my apologies, we've taken 15 minutes off that panel, and hopefully we'll be able to catch up. So I'm speaking to the moderator indirectly, but it's also an expansive panel, but we'll be able to manage. So this panel is on the role of mediation in disputes involving cultural and societal issues such as ancestral land and community land. So I think it's a very important session, and it will be moderated by Advocate Ezra Makori. Advocate Ezra Makori is here. Please let's appreciate him lest he decides to go back. Let's appreciate him. Advocate Ezra Makori is going to take it up from here and invite the rest of the panel.
Thank you. Good afternoon, everyone. Those claps are enough. I'm not used to clapping. I'm used to being told case dismissed aloud. But I'm happy the mediators have told us they've resolved it. We want to look at the next topic. I would like to welcome all the panelists to come on board. We had Justice Naikuni leading us. Where you, Judge? Karibu sana. Dr. Rispa. Then Mr. James Mudui, advocate, Mr. Caleb Nyamwange, advocate, Mr. Bosire, and Ian. Thank you very much. I'll take a minute or two as we wait for Mr. Nyamwange to come in to ask the panelists to just state their names and what they do. Starting from, I'll break protocol and start from that end. Mr. Mudu, you can go ahead.
Thank you very much. James Mutho is my name. I'm an advocate practicing in Nairobi. I'm a partner at Kaplan and Stratton Advocates.
Thank you, Mr. Mudui. Welcome. Next.
Thank you very much. My name is Ian Moirore. I work in the conservation industry, in the community development work at a place called Olpejeta Conservancy in Laikipia. Thank you.
Thank you. Good afternoon, everyone. My name is Dr. Rispo Epuhulu, teacher by profession, currently working at Kibabi University as a senior lecturer, trained and a certified mediator, and also trained as TOT in mediation. Thank you so much.
Sons and daughters of the Most High, praise. You are sons and daughters of God, because in Matthew chapter 5, verse 9, it says, "Blessed are the peacemakers, for they shall be called the sons of God." Peacemakers are mediators. Kama unataka kujua, enda kwa tafsiri ya Kiswahili. Heri wapatanishi, maana hao wataitwa wana wa Mungu. That's why mediation will never stop, because it's blessed. You are blessed. Praise the Lord. Amen. Edward Bosire. I work with the National Land Commission. I'm Deputy Director, National Land Commission, and County Coordinator in charge of Taita Taveta, having moved from Mombasa County. I'm also the Honorable Secretary in Institution of Surveyors of Kenya Coast Branch, a certified professional mediator, and a judicially accredited mediator. Thank you.
Thank you very much.
Thank you very much.
Thank you very much, with that kind of high tempo by Bosire, I wonder how I'm going to survive. All said and done, I will not associate myself with that tempo. I'm going to burn out. All in all, Justice Lucas Naikuni. I'm a judge of environment and land courts, stationed at Kwale. For some time, about 3.5 years, I was in Mombasa. And before I joined the judiciary, I was working as an advocate for 22 years as a firm of Naikuni Ngai and Miencha Company Advocates. The only firm that has produced 2 judges right now. And ironically, they are all in the coastal region. So God works in miracles. I'm trying to get somewhere where God is going to be mentioned. As they say again, that there's an agreement. So, all in all, I'm very happy to be here today to discuss with. Now, right now, I'm stationed at Kwale, nchi ya Kaya ya Mijikenda. So I'll be able to share with you a few insights here and there. But I'm happy to be here, and we shall proceed on as it were. Praise Lord.
Mr. Bosire, thank you for setting the pace.
After the one, I want to introduce myself. My name is Caleb Nyamwange. I'm an advocate of the High Court of Kenya and a certified professional mediator for this purpose. Currently, I serve as the county attorney for Nakuru and the former chairman of the County Attorneys Forum. That's all.
Thank you very much.
Thank you.
We are privileged to have a judge, 2 mediators, 3 advocates, and 1 community person from the community leading this discussion. Mediation has, Court Annexed mediation has been revolving around the disputes involving private land, that's what we know, where there are competing interests between 2 individuals. But as we well know now, some of the most complex disputes coming to our courts involve the historical claims to ancestral land, community land. And when we were having a discussion with the panelists, we discovered that perhaps this is the area that mediation could work best. It's because of the very basic definition of what is ancestral land, what is community land, and the fact that whatever decision you arrive at has to be implemented within that community. So I want to give our judge to open this session by just taking us through and trying to explain to us from his experience. He comes from a community that thrives on community land, ancestral land claims. I doubt he has land himself because he comes from that community. And then he has administered justice, I think, since his appointment to the bench in a region where these claims are very many. So we thought that he would be the best person to open with taking us through what are these disputes, how are they, can they be resolved? What is the role of the traditional beliefs in resolution of such disputes? Judge, please, if you could take us through that.
Thank you. Thank you very much, Counsel Ezra. First of all, I want to make some disclaimer, with your permission, that as we sat here from yesterday to today, we have gathered that the direction the court is moving is towards mediation. That is standard. The second point that we are moving to is that we have 14,000 cases that are pending before the 52 judges who are in Environment and Land Court. And somehow these matters have got to be resolved in one way or the other. The third point is that judges in ELC are not experts, are not mediators, so to speak. So it is high time that using the legislation or the laws that we have to pass on this particular responsibility to the structures that are in existence. And one of the structures that are in existence as per the Constitution, the current Constitution under Article 152C, which we do interact with every day, is the recognition and of the established traditional dispute mechanisms. So basically, the conversation I'm going to have with you, and I'm going to make it as I want to ride from what Justice Kibunja did yesterday. I saw he stole the day by building the confidence, and I want to get that confidence as well as I associate myself from what Makori has done using the Bible. One of the things that we shall be looking at, so that I don't make it the conversation very academic, is that what are those institutions in existence? Are they there, or we assume they are there? And if they are there, are these institutions that we can work with, so that whenever we again sending, people have come to us for cases, they have entrusted us. Then we are sending them away, but sending them away to where? Where in particular? Where are these structures? Are they codified? Are they known? Is there something that we can say, apart from the Chiefs Act? We know from the community point of view, the lowest is the chief. But is the chief the person whom the community trusts as far as the dispute resolution is concerned? I know the chief has a lot of information in terms of data, but can we entrust the chief as the person, as a structure to resolve dispute the way we have seen 2.5 hours skit here and resolving it in 2.5 hours? That's amazing. The flexibility, the impartiality, and so forth and so forth. But before we go on, what is communal? What is communal land, as opposed to? And of course, I'm speaking here to the choir. I know the likes of Justice Ochieng is here, the likes of Ambogo, and of course Angote. These are people who interacted with this legislation for a long time. Communal land, as we speak, these are land that is kept aside by customary laws for purposes of benefiting a particular group of people who are identified by law, either by culture, by ethnicity, or by clan, or by a family to some extent. And they could be registered or non-registered. So there are two aspects of the communal land. When we come to ancestral land, I want to give the distinction. Is ancestral land, a land that has been owned by generation of families from time memorial. And they have gone on, again, they're also governed by customary law. And that what is common here is that there is an aspect of customary law, customary traditions, customary ethics, and the standards. And therefore, as we are talking about mediation, these are some of the things that we have to have in mind. Now, mainly the land that is available is mainly left for the pastoralists. Pastoralist community is where you get these large parcels of land, or the lands that I've described. But now, before I go to the law, what are the challenges? What is this that makes it so difficult to resolve dispute among the traditional setup of the community, or the communal or ancestral land? One of it is that, with your permission, you'll find that these communities, due to there are people who are very emotional, people who are very litigious. Pastoralist people they love litigation. They're habitual litigants. At any small altercation, they are fighting. There's a fight. 2-3 minutes, they are fighting. These are the Maasais, the Arabs, the Indians, the Meru. You know, they tell you, ningoje padaika kidogo, nikirudi utalipata hapa. You better take off. Because the rest is going to be. And that can create complexities if you do not understand what the judge from Uganda was saying in the morning. The other issue that also creates complexity in resolving disputes among the communal and ancestral land is the vastness, the large parcels of land that these people do have. So that you are finding that the decisions cannot be made by an individual. This individual, the decision has to be made collectively, either through clan or a larger family. And you know, when you start bringing too many people to resolve or to discuss anything, decision making becomes rather complicated. Then of course there is the issue of lack of codification. There's no documentation. It's not particular. You cannot say that if I go to a traditional dispute resolution group, say in Busia or the Agekoyo, I will find a particular council of elders. And this, when you ask them, what are the methodologies that you use for resolving disputes? There is nothing, there's no uniformity. There is nothing that you can talk of. Even I would want to challenge Justice Mutungi, if Joronjeke do have, and with due respect, of course, they have something that is already codified. Now, it's important so that we are able to be in the picture and so that I can allow the other panelists to speak. I've been asked to build up on where did we come from up to where we are. And I'm going to be very quickly because this is going to be a bit boring. It's a bit historical injustices up to, because we cannot govern today if we do not know where we came from. And where we came from, for those historians who are here, it started all the way from 1886 of the Berlin Conference, dividing the continent into small portion for the colonialists, and the rest you know. Then you move on, of course, to the 1911, the Ma-Anglo Agreement, and what happened to it, the altercations, the Olenjo Ghost case of 1912, and we move on. Then we have the 1908 land titles ordinance of 1908, and this is very important for the coastal people, and I'm going to be talking about it again in depth. Of course, 1915 Crown Land Ordinance, 1919 registration of titles ordinance. All these were efforts towards depriving, dispossessing and disowning the communal owners of land, the resource that they had, their rights. The 1932 Maurice Carter Commission, 1998 Native Land Ordinance, and then of course the latest one, the Swinnerton of 1954. Then of course now we come to the independence, 1963, and then this is now where the problems begin. The Land Registration Act, Cap 300. What does this cat do? That the modernization, for you to be a modern, for you to be rich, for you to move the Western world, you must subdivide your land into small portions. Then you are given a title deed. Title deeds were things that were never in existence as far as the communal land is concerned. These are new concepts. Little do people start seeing lands are fenced. We start seeing segmentation of land, what the Chief Justice was talking about. And this changed the morphology completely of the communal land setup. And of course, the disputes start beginning. And of course, the selling of land, people start selling land, you're told, and the pastoralists are not people who understand capitalism. They don't understand market value. They don't understand, to them, what Busire was saying, and I want now to also to go back into the Bible. They go by what is there in Leviticus chapter 25, verse 23, that do not sell land, it belongs to me. That's what God was telling Moses. You are sojourners, you are strangers. The pastoralists do not know that up to today. And I would like you to read this book later on when you selling wealth to buy poverty. That is M.M. Ronted. This is exactly what happened to the pastoralists, the communal land that I'm talking about. They destroyed the ranchings and so forth. Now, the Constitution, the former Constitution, section 115 all the way to 119, created trust land. Trust land is land that is held aside for ordinarily for the people who are in residence of that particular area, but on by the county government. And that's another problem. If the county people seated here say amen. Did they again? I'm giving now the background of where the disputes have emerged in terms of historical injustices. So as we move on, there are other legislation that have been enacted. And this is, for example, we have the Land Adjudication Land Adjudication Act, Cap 284, which clearly, and I'm talking in the context also of historical injustice and also aspect of mediation. Cap 284, from section 3, it defines exactly who is supposed to be, who qualifies in that particular section, by clan, by tribe and family. That's section 3. And as you move on, two things. The act itself has a mechanism, and this is very important, has a mechanism for resolving disputes amongst the ordinarily resident or people who are registered as members of the land adjudication section, who are in the register. So that if you are not in that register, there's a problem. And this is what I'm facing in Kwale, day in, day out. But that's for another day, because of the rights of sub judice. Now, the act itself, from section 12 all the way to section 29, it gives the mechanism, self-involving. It's one of the acts that I like to interact with because it removes the court completely. I think it's only section 10 that keeps on saying, you can go to the magistrate, I don't know what. But the rest, they have a land adjudication arbitration committee, they have a land adjudication committee, and if you have action, you keep raising objections from within. If you are dissatisfied, you file your appeal before the minister. And of course, the minister's decision is final. That's the beauty about that act. So that the only time this person interacts with the court is if he moves to court under judicial review. That is prerogative, acts for certiorari, mandamus, and so forth. And that's it. If you wanted to go to court for civil proceedings, you must seek consent from the land adjudication officer under section 30. So that court, that to me, Chair, is a quick intervention of how the court can advocate for mediation. It's already legislated. And that applies also to the Land Group Representatives Act, Cap 287, I guess. It also makes that provision. Now, the latest legislation. Of course, we have the Constitution of Constitution of 2010, where again there's a problem in that Constitution, and this is my own view. It classifies land into three categories. Category 1, private land. I have no problem with that. We said Land Registration Act, Cap 300 brought individualization. I have no problem. Private land and so forth. My problem begins with what they call public land. Public land is a lie. Public land, and that is Article 62 and 63, if you read them closely, actually this is community land, but clothed in the name of public land. So, but we leave that for another day. Article 63 defines clearly what community land is. It's land that again set aside for the ethnicity, people who belong that area, for their own use. And that use has got to be sanctioned by the members of that community. Again, the act says, I think that sub 4, that land is not to be disposed of. The selling of land is already being stopped, being condemned. Now, immediately after that, now we have the enactment of the Community Land Act. Community of Land Act, and to me this is very important, in that the community land is actually clothed from the Israelites' method of kibbutz, the kibbutz system, where you utilize the land, the community is allowed to utilize land for purposes of creating wealth and economic value, but not for sale. Pastoralist community, the people who are owning communal land, we are saying and we are condemning it, please, no selling of land. So communal land is, community land does create that. Now, my sister Justice Mbogwa did allude to section 39 and 40. Express gives a provision for mediation, making reference for dispute, specifically for mediation and arbitration. So that is the first legislation that I've seen in the community that introduces mediation, resolving of matters. And again, that chair is another intervention that we can. But I do not know why this particular legislation is not yet being implemented. There's a bit of reluctance in implementing this particular law. So I guess with those few remarks, I'll still come back again. You can see how passionate I am. But, for now, because I'm acting under instruction, I had yesterday somebody answering questions that was. So I would like to stop there. It's a good curtain raiser. Then I have the appetite to come back again and provide more input with your kind permission. Asanteni sana.
Thank you, Chair. Thank you very much, Judge. I think you've heard from a pastoralist and a judge. He's very passionate about it. Perhaps, Ian, you tell us, in your engagement in Laikipia, as you work at the Conservancy, what kind of disputes have you encountered? What form of disputes have you seen arising from the likes of the first presenter?
Thank you very much. I can assure the audience I will not be quoting any laws. I think the judge has taken care of that. To be very honest, when we were discussing some of the questions here previously, and some of the things he's mentioned actually are very close to what we face every day, because in the conservation space, both community and private conservancies, they have a very huge appetite for land, and a lot of land is needed for. And that can often be controversial, obviously. Now, when we are doing this work, I want to maybe go back to something he said. I think I'm having a dispute with the microphone. The kind of disputes that we face when we are doing this kind of work. For example, from a cultural perspective, we are not starting from zero. We had very many mechanisms that existed to solve disputes, but they were demonized a little bit by colonialism. I think, for example, you hear that, to use a different example, medicine men and women, before colonialism, they were healers. After witches, right? So, in the same way, some of the arbitration and mediation systems kind of were taken away and they disappeared in the tapestry of the Western litigation. However, the main issue, of course, is land. Most of the issues about land are connected to resource sharing. Now, because of climate change and the environment situation right now, a lot of disputes that did not exist in the past have become relevant. I'll give an example. We talk about pastoralists. Pastoralists are probably the most efficient users of land anywhere. Because the grass that they consume and they give their cows, or the cows consume, that grass is useless to most people. But they go and they use that grass, they make meat, they make milk, but they don't. However, with the issue of, again, reduced water catchment areas and reduced space for grazing, the amount of conflict coming up between now pastoralists and farmers is going up. Now, most of this conflict is solved using local channels, common sense, council of elders, especially the Samburus and Maasais are very strong at that. And majority. So, and majority of the conflict that gets the judges is something that has been tried and tried and tried until eventually they decide, let us go to court. But now in the context of mediation, I think we also need to bring a presence for the judiciary down to the community level. Because a lot of the times people don't want to do mediation because they don't really trust each other, which is why they're having a conflict in the first place. So if you suggest mediation and you're going to bring a lawyer or involve someone automatically assumes that you won't take advantage of them. So I think it's a challenge to the members of this panel. It will be important for us to put ourselves on the ground and let the communities know that mediation is an option. It is legally acceptable. It can be fitted with what the judiciary does. And in that way, we can create, the judge says he has 14,000 cases. There is no benefit to adding 2, 3, or 4. others. Actually, it might be better for us to figure out how do we reduce the whatever is on his docket. And Chair, if I may, there's a job you had given me. I think I'll just finish it one time. No, not tunapatiwa warning here time. I was supposed to discuss some of the main issues of conflict. Should I do it now?
Main conflicts.
The main systems, yeah. So of course we have the Council of Elders. I'll not school anybody about that. We have the communal assemblies, but in the communities out of restorative justice that happens on the site. And this includes whether a very serious crime has been committed, whether it is even someone has been killed, someone has been injured. The communities have systems that are age-old that allow us to sit down, and as long as both parties agree, this allows people to handle these kinds of conflicts. Someone gave a very good example in the previous session. And then there are rituals. When I spoke about demonization, a lot of communities still believe in their traditional cultures and their gods and all that. In the same way we have Sharia law, a lot of communities actually have very strong traditional beliefs that go around their deity. So you find that sometimes we hold blessing ceremonies, for example. People used to go to war or they go to raids and then they fight, two cultures fight for a period of like 2 years and then they say, we're done with this. So they hold a communal blessing ceremony. That ceremony does not involve any judges, any lawyers, but they come here and say, we are going to stop fighting, we are going to kill a sheep, we are going to put his blood on this ground. But again, these things again were demonized a little bit. So there are a lot of traditional rituals that exist. And when I cannot say we go back to all of them, I think it's important we start looking at hybridization. What courts handle, but what the courts cannot handle, it is easier for community to deal with independently. Then it is done independently. And finally, the gap that exists right now is a lot of community land and public land. It is not clear what is what. So sometimes something is called public land, according to the law, but the community members know that this is communal land. They have a right to graze there, to harvest honey, and all that. So sometimes if you try to legislate that officially, you end up causing even more conflict. But if we are finding that lacuna between what is in the law and what is in practice, I think that is where the main or primary role of mediation will come in. Asante sana.
Thank you very much, Ian. Pass the mic to Mr. Mudui. Mr. Mudui, as a practitioner, Ian has referred to some various modes of locally available solutions, which mediation can tap and use. How appropriate are some of these methods he has mentioned?
Thank you. Thank you very much, Ezra. And maybe just to mention one other area of conflict, which may not necessarily be purely about communities, is disputes between communities and individuals, private persons. I deal, for instance, quite a bit in the area of energy sector. And what you'll see is that when a project is being developed, for instance, say it's a power station which is being put up in a place, some of those, they are done in areas where communities are. And therefore, you have disputes between the developers or the private individuals who are coming up with such projects and the people. Coming to the question of whether those traditional dispute systems are appropriate, I am actually a very strong advocate of those traditional methods. And the reason is, I think, first of all, we need to understand that the African communities had these methods of dispute resolutions within them, including mediation. We are not trying to create new methods. Mediation is not necessarily a Western thing that is being introduced to us. These are methods that pre-existed. They are methods that have been there time immemorial. So it's a question of taking our own methods and mainstreaming them and using them to resolve disputes. Why do I think they are appropriate? Number one, they are embedded in our cultures and our customs, and therefore they enjoy legitimacy. It is a very difficult thing when you go with say a judge, a court has delivered a decision, and you take it to the ground. You have a paper judgment. In some instances, it may not enjoy the legitimacy with the people on the ground, especially communities. Why? Because they do not understand where the judge is coming from in terms of the judgment they have made. But when you involve the traditional methods of resolving disputes, these are things that the people understand, therefore they enjoy legitimacy. And as a matter of fact, I think in terms of compliance with the decisions that come from those systems, there is very high degree of compliance. Why? Because of the question of legitimacy. Number two, they are very accessible to the people. I mean, if I've done some disputes involving some of my good friend Justice Naikuni's community in certain sections, and it's very difficult to have the entire community. They want to come for the resolution of the matter in court. Again, let me just use Justice Ogote. How many of them can you bring to Justice Ogote's court? But when these systems are taken to the ground, maybe arbitrarily where they are accessible to them, they understand what is happening. Some of them are done even in their own languages, and actually it should be the case if at all there is congruence in terms of the interest and the understanding there. So they are also accessible. And finally, for me, unlike the Western justice system which we have now, which is very much about retributive judgment, retributive justice, the traditional methods are very restorative. They are concerned about harmony in the communities and the societies. They are concerned about the very values that we uphold as African communities. So they actually promote restorative justice as opposed to retributive justice. And with that, I would firmly say, not only are they appropriate, I think they are very appropriate.
Thank you very much, James, for that. So that we are not just speaking theoretically. Daktari, you've done a lot of research. Could you confirm to us whether, starting from where you come from, we have these systems? Do we have any leadership structures to handle these disputes so that when Judge Naikuni decides to send these disputes down there, they are sure that they will find someone to handle them? And how do they work?
Okay, thank you. Good evening once again. I want to pick up from where my colleague has left. And I want to confirm that indeed we have Council of Elders that exist. And from where I come from, we have a very serious one, a strong one, the Bukusu Council of Elders. And for you to become a member of that council, you must have attained 60 years and above. Meaning you must be someone with experience, someone with knowledge, someone who knows exactly what is happening. Now, what I want to confirm to the sitting today, or to the summit today, that traditionally we had the arrangements in which issues were handled by the elders. And as we have moved on, I come from the teaching background, I've already said that. I'm not a lawyer, but I may quote probably a section of the Constitution, going by what I heard yesterday and today. But these, I want to say that in the historically or traditionally, we had mechanisms that were put in place that were able to help the communities handle issues that were arising with the time. And most of those issues that were coming up, first of all, they went straight to the local elders who are within that particular area. Like now we talk about the Nyumba Kumi, I think you have heard about that. Then we have the village elders who have been in existence for a long time. Then once the information gets to the chiefs of the area or the location, then now the Council of Elders can be able to pick up the information. And indeed they have helped the communities live in harmony because of the methods they have put in place or the mechanisms they have put in place to ensure that issues are handled at their level before they are escalated to the next level. Now, from the African communities and more so the Kenyan communities, I believe in all communities we have those Council of Elders. We have talked about the Njurinjeke, they exist. I'm sure among the Samburu community they exist. And all the communities in Kenya or beyond Kenya, they do have these structures in place. The only challenge that they may face going forward is that they may not be legally recognized. They exist, yes, they work and they do a lot of work, but they may not be legally recognized. And with the time, as we move on, there are some elements of political interference where even some of our elders among the councils or the chiefs are likely to be compromised so that they come up with the decisions that affect a particular party that may favor a particular party as opposed to the other, to their opposing party. So these are structures that are there. And when you look at it critically, they are what we call the custodians of our customer land rights. Without them, we may not know the boundaries of those, the community land that we're talking about, the public land we are talking about, the private land we are talking about. So in case there's anything, they are normally consulted to come up with a solution to issues that may be arising. Apart from that, they exist and they have been mediating, and some of them are served as arbitrators. And I want to confirm, like where I come from, maybe something I didn't mention. I'm married to one man who is also a member of that council of elders. So in most cases, we do mediation even in our own houses or in our own house. And he's an arbitrator as a man mediator, because we know at one time, because of our culture, a man is the final decision maker. So in our community, we have such arrangements where mediation is done at all levels, where it doesn't work well, arbitration comes in. And if arbitration doesn't work, then the local leaders now will come in to do what? To help us. And this means that as communities, the African communities, we do embrace the traditional dispute resolutions. Apart from that, when you look at the structure of the African communities, before this formal level of education we talk about, we didn't have records. So we are now relying on the Council of Elders for the records. So they are living archives. If you want to confirm the boundaries, if you want to confirm the particular family which is at dispute, how things were being done, where the boundaries were, we go back to the elders and they provide that kind of information. And in our communities, the African communities and the Kenyan case, for example, they have been able to work on social cohesion. How does that work? It works in a manner that if we have issues, as one of my colleagues has said, they will either use rituals or they will force one to apologize, or if not, you'll do some compensation in one way or another. And at the end of it all, we continue living in a harmonious way. Why? Because the Africans believe that life starts with the family and life ends with the family. If families are stable, they are functioning, and we can live together in harmony, they really focus on families and how to ensure that we have a harmonious relationships that exist among families within our communities. And lastly, these Council of Elders, they also enforce what you call customary laws. Anyone who goes against what is established in the African setup, you are actually summoned, you are talked to. If you don't change, like I've seen in some communities, even where I come from, my own clan, if a young man is messing up himself, walking around doing things that are antisocial, he's summoned and he's given good strokes of the cane with no response. And that has really worked, because the young men from where I come from, they fear our clan, because they know the moment they make a mistake, they will be summoned, and imagine you will be beaten in the presence of the family members, and you apologize publicly. So I believe these Council of Elders are there, they are existing, and they are working, they are carrying out their work as mediators and arbitrators using the traditional dispute resolution. Thank you so much, Chair.
Thank you very much. Let's clap for her. Now, I want to move to a very important constituency. We've confirmed that these disputes exist. We have traditional modes of attending to them, and they are working. I want to hear from the National Land Commission and the counties, because they're represented here. They confirmed to us whether, number one, they've tried these mods, so that when as a judiciary we decide to send our disputes there, it's a tried and tested system. Mr. Bosire, as NLC, you are facing these disputes. People are calling you the animal that came to eat the pastoralist land and call it public land while it was community land. How are you, have you utilized, number one, have you utilized these traditional mods to resolve these disputes, and are they working?
Thank you, moderator. I have very many good things to speak on. You will give me more time. Let me start with coming to the defense of the mediators. Yesterday they were a bit, they are feeling cold because they were told to learn. Go and learn about land. How are you mediating land? You don't know laws about this. And you know, don't go to land. Don't go to school. Mediators. If you go to learn about lands, you'll take so many years. You want to be a lawyer, you'll take many years. As a surveyor, by the time you complete this, you should have not assisted as a mediator. Go do more mediation courses, get refresher courses, be a TOT, etc. You are good to go. I'm only assisting you now. How do you navigate about matters of land that you are not aware of? I'm giving you something. And I'm bringing a very important institution to this summit. This institution, I took it to the CUC, Environment and Lands Court in Mombasa, to Judge Naikuni, Judge Kipunja. I took to them the Institution of Surveyors of Kenya. Let me tell you. Most of the disputes that we are solving now, they are a creation by the landed professionals. Professionals are the ones who have created these conflicts, most of them. Let me, I'm also a professional, but I've not created end of. Okay, now, let me tell you, land allocation. Land is allocated wherever. Who allocates land? A land officer. A land officer is a member of the Institution of Surveyors of Kenya. In fact, he belongs to a chapter called Land Administration and Management chapter. He's a so that there is a stamp premium, stamp duty is a valuer. There is another one called the engineering surveyor. There is a real estate agent, there is a property manager, there is a geospatial information management surveyor. All these people, they are members of the Institutional Surveyors of Kenya. So therefore I'm saying, the people who have created problems are Institutional Surveyors of Kenya, and I've not heard you speak about the Institutional Surveyors of Kenya. Now those are the people who will assist us again to solve the problems they have created. So that's why I took the chairman, I'm the secretary Coast Region, I took to the chairman, I moved a motion in the CUC, Environment and Lands Court Mombasa, that they agree, they accept the chairman of the branch to come to the court, so that they can be aware of these cases. In fact, I told the judges, once there is a matter filed in the court, let the chairman know. If there is land which has been allocated in the water, there are lands allocated in the water in Mombasa, so that the Institutional Surveyors of Kenya can take up the matter. As the matter is progressing in Judge Naikuni's court, the Institutional Surveyors of Kenya will be analyzing and seeing what you did. Did you do professional work? The land officer who allocated water, you are asked, did you allocate the water or you allocated land? Because the title is in water. Then there is this valuer. We ask him, we call him to the disciplinary panel of the Institutional Surveyors of Kenya. Did you value water or you value the land? He has to tell us. The surveyor, we ask him, where did you stand when you were placing beacons? The surveyor. So he has to answer us this question. So much so that when Judge Naikuni will be issuing a determination to revoke the title, he also revokes these officers. Because, we should have given him a report that us as the Institutional Surveyors of Kenya, we do not approve this. And then there is something called good standing. Then we write to the CS lands. This officer does not have good standing. National Land Commission, this officer does not have good standing. So that he goes to do another business. There are so many businesses, even agro business is business. So therefore, I am bringing I told this to the president of the Institution of Surveyors of Kenya that I'm speaking about this one, and I've spoken. I've already had a seminar with them, and I told all the Institution of Surveyors of Kenya professionals, the land problem in Kenya are creation by the professionals. They were saying, "Achana na huyu, this man is an SDA, Seventh-day Adventist," saying, "Huyu achana naye." So, but that is the reality, isn't it? So, therefore, what I'm saying is, now, the professional, the surveyors, I mean the mediators, when you are doing this mediation, then somebody is talking about this title is fake. Don't wonder I'm not a trained land. You should not, even me who am a land administration and management expert, if they say the title is fake, I'd say, oh, go and do, okay, now what do you agree? Go and do a search, and then we adjourn the session until when do we come? Okay, a week or something like that, isn't it? If I look at the title and say, the title is okay. This one say, this one is favoring. So my neutrality disappears. So therefore, you don't need to be, because you need to be a trained land officer. So what? So that you tell them what you know. No, you have to be neutral, isn't it? There is a matter which I solved. Okay, I just want also to ask the parties. The parties, there is a matter which I'm going to mention about, which is going to be a best practice nationally, regionally, and internationally. Once I come to it, those who have come from there, take this method that I've used. So, and, okay, I'm saying this. The courts, kindly write, we can do an SMS. If for the mediators, you feel there is a matter which has cropped up, which needs land expertise, go to the DR. And I've done that several times. You make a prayer to the court to allow you, someone, a party who is not party to the dispute, to come and assist in conciliation, not reconciliation, conciliation, just to give an opinion. Say this one is like this. There is a matter which I got a title. There is a matter which, the one I want to speak about, the parties were saying, okay, the parties were saying this title is fake, simply because it changed from RTA Cap 21 to Cap 300 RLA due to conversion. You see? So then I had to say, okay, can we call the surveyor? I mean, the land registrar? They agreed. Then I asked the land registrar. The land registrar said, this is how a normal process. If the conversion is done by the registrar of lands. So I was saying, the registrar, so the titles are okay, or what are you saying? So that I also look stupid, look like them, so that we say, okay, the titles are good, let's proceed. Okay, good. Now I've moved from that. I made a request to the DR, the deputy registrars, to
let's hold that thought there.
Let me go back to the commission mediation.
I'll give you time. I'm excited to listen to him because for the first time, lawyers have not been mentioned that we are causing problems. But Mr. Nyamwenge, perhaps you chip in, you add into what you said in terms of the disputes we are having from the counties forum. I know you convened the County Attorneys Forum. How can we use this tool of mediation to build on the dispute resolution process and bring peace in the communities?
Thank you, Chairman. I want to start by giving a rejoinder to Justice Naikuni's amen issue. Counties don't just say amen. They are active participants in issues of mediation. And I only wanted to give 2 examples on issues that were likely to cause bloodshed, and they have been averted by some action on the part of the county government of Nakuru. I won't go into many details because some matters are still pending in our courts. In Naivasha and Nakuru. So I'll start by dealing with the issue of Ngate Farmers Cooperative Society in Naivasha, Maela area, which all of us are aware of. In 2019, the then governor constituted a task force to resolve the issue by way of mediation. Sittings were done all the warring parties were brought to the table. They gave their sides of the stories to the task force that had been established, and recommendations were given. Those recommendations were required to be implemented by some ad hoc committee, which was also established. And it's in the process of implementation, and I think since that time, we have not had issues from Maela. Number two, the issues of the local resources, where public bodies have taken up some land that is perceived to be private or communal land in areas in Naivasha, the Kengen area. The county has been able also to mediate that issue with the local community. And the Kengen has actually undertaken CSR to the satisfaction of the communities. So there is that good relationship that has been created. They have also invested a bit of monies in the medical sector in conjunction with the county government. In Naivasha, that is a facility that is worth about 310 million. And those issues will be seen in other counties because I represent the Council of Governors. Even from the windmills in Nyandarua, you can still see them. And now the county governments have come in to mediate disputes. We have suggested to the council that going forward, other than the court-annexed mediation, we can, on our own part as counties, initiate mediation processes even before they land in court. And counties have undertaken to establish fiscal facilities, and they have even trained some mediators so that matters that don't have to find their way to court are sorted out before they are filed. I think you are under some pressure, Ezra, but we are available to give rejoinders if they are required.
Thank you very much, Mr. Nyamwange. I want to throw it back to Mr. Mudui. In the morning, there was a rich discussion on international, from what our neighbors are doing internationally. We have had success stories from Mr. Nyamwange, which are quite inspiring. From the county governments, we've had a lot of success stories between ourselves in our chambers on what mediation has achieved. What do you pick from all this? Are there any best practices internationally that we can tap on?
Thank you. Thank you, Chair. And I think I'll keep it very brief. Let me start with one of the cases that Council has mentioned, just to give an example of success stories. I think the case of Kengen, for me, or Carrier 4, is a matter that really must inform us that even in disputes involving communities, mediation can be very, very helpful in resolving those disputes. I think if you understand what was happening there was this project, the Olkaria, which was being done, and the Maasai community, a section of Maasai community was going to be displaced. And therefore, the Maasais were raising I think, 3 questions. Number 1, number 2, settlement, new places, and number 3, the environmental concerns. And that matter was referred to mediation. I believe that if it remained in court, perhaps the judges would still be struggling with that matter, because it was just recent, 2023, the project would not have happened, and such other things. Compare again with the example Kinangop Weed. In Kinangop Weed is a situation where communities were, in a sense, made to think or to understand that the weed mills were going to cause harm to them, especially the men. I think if you understand the details. And I think that is a matter perhaps which could have gone to mediation and resolved the dispute in a way that would enable the project to go on and take care of the interests of the communities. Because most of the times is, how do we safeguard the interests of the communities. In terms of best practices, I think they are not different from these other areas of disputes where it comes to resolving these disputes involving community interest or communal ancestral right disputes. They are more or less the same. And I'll just mention a few of them. One of them is the appointment of a suitable mediator. Of course, as you can imagine, most of the community disputes involve larger sections of people, not just one individual. So you could have a situation where the mediation is not about two people sitting in a boardroom. You have sections of the community which want to participate in that. And I think ideally ensuring that we appoint someone who has the cultural context of the parties involved, who is, of course, impartial. All those are critical things. If, for instance, you appoint a mediator, let me say from a certain section, which that mediator doesn't have the contextual, where the dispute is coming from. Some of these things are about history. They're about interest. They're about unspoken disputes. So the appointment of an appropriate mediator is a key thing, because if you don't, then it becomes difficult to resolve the communal concerns. The second one is the communities themselves understanding what is this mediation, especially if it is coming from the court annexed mediation. They might just see it as another extension of the judiciary. Yet mediation is a part, as we said, of the African way of resolving disputes. But if we help them to understand that what is happening here is that we want you to come and ensure that you have a conversation, you express your perspectives, your feelings, your expectations, and the dispute resolution is coming from you. When they do understand that, I think it's a critical thing for ensuring a resolution of the dispute. The third one is a communication within the dispute resolution itself, in the mediation. I think we have seen situations where maybe mediators lose control of the proceedings and you have parties shouting at each other. I think it's critical for mediators to ensure that the communication is effective. As we saw in the skit, let one community or the disputing parties express themselves, let them say their perspectives, their feelings, their expectations. Let them do that without interference from the other side, and giving them the comfort that whatever issues the other side will have an opportunity to address. Incidentally, communication is not just the verbal communication. In fact, research tells us that 55% communication is non-verbal. And even the part, 38 is about how you present, not what you say. The tone, how you see it, how you are communicating is critical for resolution of the dispute. And only 7% of what is said is necessary for that conversation. So I think it is critical that as we conduct mediation, to ensure that that is done, the communication is effective, the environment is conducive, all the parties are comfortable, and then once they arrive at a decision, and maybe the mediator also looking at the obstacles. Because remember, for communal interests, as I think my sister said earlier on, politics, modernity, and all those are factors that are also contributing to the hindrances in resolution of disputes. So a mediator really needs to be able to see what those hindrances are and help and encourage the people to arrive at a decision. And lastly, of course, I think once a decision is made, it's good to congratulate the parties, let them feel that they have given themselves something that is worth living with, and I think understandably also make sure the signing is done fairly quickly before people go and change their mind.
Thank you very much, James. I would like you to pass the mic to Ian. After that very rich discussion, Ian, in 1 minute, your parting shot to this sitting.
Thank you. I think from what has been said here and from what is talked about right now, the issues that are causing this conflict in the community are increasing, not reducing. Desertification is why people are fighting more for grazing land. and water. It is not going down, it is going up. So we need to be better at this. We need to give more legitimacy to mediation, and even from a retrospective viewpoint. If a case is brought to the court, usually the judge tries to handle it, and then if it's too much, 20 years, whatnot they're like, can you go and try mediation? Sometimes you find that there are people in the community who have been mediating, and maybe they did 75% of the job, and then they disagreed, so they ran to court. So I think there might be value in finding out, even mediated, have we gotten, so that with time, because I think it's been proven beyond a doubt that mediation is a better alternative for most of the cases we are handling, so that we give the court a chance to deal with more complex issues or more serious issues, so to speak. And then most of the community disputes can be solved using the tools that already exist, so we don't have to reinvent the wheel. Thank you.
Thank you very much. Dr. Ari.
Okay, thank you. I wish to say that that let us go out and be lead by as role models, sensitize the community that indeed mediation works. And apart from that, I want to welcome you to Kibabi University, which was voted the best university in performance management because of the activities of mediation. Then lastly, I wish to say that as I sit here, I'm honored to be here. I'm the only lady in this, you can see in this panel, and I think it's an honor. And state it clear that I'm humbled, and I wish to appreciate Strathmore University. We relate in a special manner. My daughter is here. She was here as a student, but she's also a lecturer, Purity Namasaka, and I want to appreciate that. Lastly, I wish to say that as we leave this place, let us live with a changed attitude towards mediation. Thank you so much, and God bless each one of you.
Thank you.
The National Land Commission does not only encourage traditional dispute resolution mechanisms, but under Article 252(1)(b) of the Constitution, it uses negotiation, conciliation, and mediation in its processes. It has made mediation or alternative dispute resolution a performance target to all the county coordinators. So the county coordinators are really doing a lot of mediation, and the commissioners are mediators themselves. They mediate up there. At the end of this year, when there shall be an exit report, you will see how many mediation cases have been done countrywide, very many. Am I batting short? Okay, we have been able to solve cases even in a single day. There is one case in Taveta Court which had lasted 51 years. Taveta Court can confirm we mediated it in a single day. So mediation works. So my batting short, Matthew 28:19. Go ye and make disciples of all nations. Therefore, go ye and make mediators of all nations.
Thank you very much. Please pass it to the judge. Just judge your parting shot.
Oh, okay. Thank you. Yeah, I thought you're going to give me another chance, but that's all right. In terms of
Judge, pause there. I think I'll withdraw. I pass to Mr. Nyamwanga because I want him to respond to something very specific. Then you crown it all, because I remember you had something to say. Mr. Nyamwanga, the national government has what we call community health promoters. We are just cascading down the provincial administration and trying to address a certain sector. The chiefs are there in place, but we are telling the judiciary that it's possible to work with the clan elders and other structures to resolve land disputes. Do you think the county governments have capacity, if they are called upon, to give us access to these? Because there was an issue of trust raised, that the chiefs are not so trusted with land. Can the county government, through the sub-county administrators, be the entry point to the very lowest area? As a parting shot from you.
Thank you, Chairman. I want to assure the audience, Chairman, that county governments are ready, able, and willing to support in terms of mediation. If you look at many of the counties now have legislated the law on village delineation, and we are going the Indian way, the village panchayat system, so that these facilities, Mr. Chairman, will be available from the village level all the way to the sub-county administrators. Thank you.
Thank you very much. With that assurance, Judge, you can crown it now for us.
Thank you very much, Ezra. First of all, I would like to, still on the intervention of what ELC court can do in terms of coordinating mediation through the traditional dispute resolutions. The legislations have been said. Yesterday we talked about the civil procedure 2010, I think. At the case management, that is Order 11, Rule 8B, makes a provision now you can send cases for mediation as one of the conditions. So that is one is good news. Of course, I don't want to talk about Section 59A, capital A, B, C, and D, because Lucy, my sister, did talk about that in the morning. But I want to emphasize what Daktari has said in terms of the traditional setup. We totally agree. The Maasai community, they have the Loibon, they have like Gwanak, we have all those setups are there. So I want to support you. Elders are respected, elders are knowledgeable, and I come from a community which is a talking community. Ask them to speak from morning to evening, they are fine. So resolving their problems is not going to be a problem. The only thing is that I wanted us to have a proper codification. I want us to have a rule. And I know customs also differ. We have segmented custom traditions which are not in tandem with the legislation. So what I could propose here is that we can have a hybrid method where it's accommodative for everybody else. Regarding restorative justice, we said mediation should not be repugnant to the constitutional provisions and also human rights. Beating people, I persuade you, the Bukusu, please don't punish. Don't beat. What we do in Maasai is that we ask you to pay in livestock. We pay cows. Even for death, we've solved what you call blood money, nyamu. You get good case. We're going to get cash if you don't pay 49 cows to that clan, so that you cleanse that clan, and it works very well. We are a fighting community, but we don't beat. Please don't beat. There are cases, Chair, allow me to say this. There are cases, and I'm saying this because I sit in the ELC court, and I practice for many years on land matters. There are cases I want to persuade my colleagues that let it go. There are cases which are pertaining to communal land and ancestral. And I can see we are struggling. I'm not saying. We are really struggling. And I think the salvation has now come. Mediation. The cases of hunters and gatherers, the Ogieks, the owners of forest. Ogieks actually conserve forests. They depend on honey. They don't burn charcoal because charcoal is going to send bees away. They don't plant pyrethrum because the bees are going to eat, and they live there like the Maoris of the New Zealand. And please let us agree that that's the direction we are going. I've seen cases of Ogiek and Toros have even gone to African Court of Justice because the municipal law is either we have exhausted, we are now unable to resolve this. The Mao forest is still with us for 8 decades. Can we try mediation? Can we send those people now to mediation and see whether those cases can be resolved? To me, that is the proposal I'm making. Finally, and I want to make 2 points finally. The issue of natural resources and conservation of what Ian talked about. There could be success story. The geothermal with the Maasai community, the Kidong, just aspect of it. We also have the Kipeto in Kajiado and its work in the wind. But the others which are sad story, and we must agree, the Tulo in Turkana, we do not know. The community have been left in abject poverty up to today. Nothing has been resolved. What happened? There is oil, but people are still poor. Even my friend here from the county government, what are you doing? Mediation. Let us take these cases for mediation to resolve them. Natural resources, matters natural resources. You found the natural resource there. Let it be for the benefit of that community that is the natural resource has exploited. I had promised, I know this is a land use mediation conference, climate change. It will be wrong for me not to mention something about climate change. And I'm asked permission from my sister Lucy, Waithaka, Obaga, and Jane Onyango. There's a live case right now by the Tugans, and the Chamus. They have filed a case, the first case, I think, where they are suing the Kenya government through Kituo cha Sheria, that the Kenya government has failed to instill resilience and adaptive capacity, so that floods have come and destroy all their habitation, schools, plantations, maize, and so forth, and they want to get compensation. This is a case that is before our courts, and we are all very eager. It's going to set a precedent. We see how things move, but there is hope, Mr. Chairman. Asante sana. Oh, just one more thing. Why are lawyers shying away, like the Mombasa MLS? The truth must be said. One, our never on mediation. We were taught on adversarial system. Even moot courts. You lose a moot court, and you want to kill your friend. So why are you sending me to mediation? That's defeatist. So until that mindset, that paradigm, we must have paradigm shift. That mediation is also part. Somebody said something good there. I think it's a judge from Uganda. That you are still going to be paid anyway. So you are not losing it out. So lawyers who are here, for hope. The second thing that I know that lawyers fear mediation is about
Why don't you? I think you've done a good job. The lawyers in the house, whether you are a judge or a lawyer in practice, clap for yourself. Thank you very much. This is because he says we are afraid of the bread, but I think things have moved. Since the promulgation of the mediation rules, a lot has changed. We now embrace mediation. I was attending a lower court in, I think it was in Kericho. And the first order of business in the first mention was go to mediation. So there's no discussion. And so that you ulainishe line yako, sisi tumenyorosha yetu. Thank you very much and have a nice evening.
Okay, thank you so much. The last panel of the day. So we are a bit late, so I will keep it short so we can quickly conclude. Honorable Justice Boaz Olao will help us award this team. Let's appreciate the good judge as he comes to assist us. Okay. We will start with Honorable Justice Lucas Naikuni. Yes. Let's appreciate the two judges. Okay. Dr. Rispa is going to be next. Thank you so much, Dr. Miss Benta Musima. She's not here. Okay. Mr. Ian.